This is Barry Alma speaking for Claim School Incorporated's blogs, Alma on Insurance. Today we're going to talk about excusable neglect and how that defeats a default judgment against a person who was damaged by an insured person. Notice of suit that sticks into an email junk folder and is never seen by management can be grounds to set aside a default judgment. Although every corporation should control its email and make sure nothing important goes into the junk email, we who get hundreds of emails every day understand why it can get lost and why that might just be an excusable neglect. Natalia Davidenko appealed from the December 13, 2023 judgment entry granting defendant King's Landscape's motion for relief from judgment and leave to file an answer in stanter of the Stark County of Common Pleas in Ohio. In a case called Natalia Davidenko versus King's Landscape and Bobcat Work et al., the Ohio Court of Appeals on November 26, 2024, acted fairly on behalf of all parties. The case arose when DeVault was operating a dump truck owned by his employer, defendant King's, and lost control of the vehicle, causing considerable damage to Davidenko's property. Davidenko filed a claim with King's insurance company, Liberty Mutual, and received payment in the amount of $45,861.03. This amount did not, she claimed, fully compensate Davidenko's damages, and she sued, asking appellants on July 13, 2023. Service was completed against both defendants by certified mail. Service on default was perfected on July 21, 2023, and on King's on July 27, 2023. Neither appellee, neither defendant answered Davidenko's suit, and she moved for default judgment. The motion was granted, and at a damages hearing, the trial court found Davidenko was entitled to damages in the amount of $179,394.76 plus interest, a great deal more than what Liberty had paid. On November 22, 2023, appellees filed motions for relief from default judgment. Appellee's motion for relief from default judgment included an affidavit of Laura Lee, an office employee of King's, offering an explanation why appellees failed to timely answer Davidenko's complaint. Service at the statutory agent was perfected, but King's remained unaware of the lawsuit because Lee never received or viewed any notice of the lawsuit from the statutory agent. Upon receipt of the default judgment, King retained counsel and a single email from the statutory agent notifying King's of the receipt of legal documents and containing a link to those documents in a document repository was located in King's junk email and was overlooked by the company. Upon learning of the suit from DeVault, David King delivered the lawsuit documents to Lee and the company's agent at Busha Okeson Insurance Agent, who retained counsel on appellee's belief, and who filed the ensuing motions for relief. On December 13, 2023, the trial court granted appellee's motions for relief from judgment and leave to file their answer. When the defendant fails to plead or otherwise defend an action, default judgment in Ohio may be granted. Same applies in most states. To prevail on a motion for relief, the movant must demonstrate that 1. The party has a meritorious defense or claim to present if relief is granted. 2. The party is entitled to relief under one of the grounds stated in the statute. And 3. The motion is made within a reasonable time and where the grounds of relief are not more than 1 year after the judgment, order, or proceeding was entered or taken. The decision whether to vacate judgment rests within the trial court's discretion and will not be reversed, absence an abuse of discretion. An abuse of discretion is more than simply an error in law, but rather implies that the trial court's attitude was unreasonable, arbitrary, or unconscionable. The Ohio Supreme Court has advised, though cautiously, that where a defendant presents a meritorious defense in a timely manner, any doubt on the categorization of neglect should be resolved in favor of the motion to set aside the judgment so that cases can be decided on their merits. Regarding King, it is the general principle that relief from default judgment may be granted on excusable neglect when service is properly made on a corporation, but a corporate employee fails to forward the summons and complaint to the appropriate person. The trial court found King's employee's affidavit was credible. It is well settled that it is for the trier of fact to judge the credibility of the witnesses and not for a reviewing court. In the absence of evidence which reveals a complete disregard for the judicial system and the rights of their adversary, appellee's motion was properly determined by the court. A finding of excusable neglect will stand absence a showing of an abuse of discretion, and generally the concept of excusable neglect must be liberally construed. The Court of Appeals therefore concluded that the trial court did not abuse its discretion in finding that excusable neglect existed in this case, and it is reasonable to conclude from the record that appellees and those acting on their behalf did not show disregard for the judicial system or Davydenko's rights. Therefore, the order of the Stark County Court of Common Pleas was affirmed. In my opinion, the appellee who settled with the plaintiff, Davydenko, did not obtain a release for the funds paid to Davydenko on behalf of the King's defendants, and therefore was not sufficient to protect it from the further suit. Why can only be considered as inept claims handling. The insurer then obtained counsel on behalf of King's, removed the default judgment, and is now defending the suit. A competent adjuster would have reached a settlement within the limits available and defended its insured if it could not obtain an agreed settlement. And if it made a payment, it would have required the insured and the defendant, as well as the plaintiff, to have mutual releases so that litigation could be avoided. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of the blog posting, usually 5 or 6 a week. And you'll also gain access to the more than 4,900 blog postings. You can also subscribe to the videos on YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in thoroughly greater information about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing to my Substack publication. And please excuse the delay in posting to this blog, since for some strange reason I managed to acquire a case of pneumonia, and hopefully my visit to the doctor this morning will resolve that problem. Thank you for your attention.